Welcome back to my Module 2, Legal Aspects of Preventive Procedures and Agencies Attributions of the TOT. I'm Achille Campagna once again, and this is the second part of my session where we will be discussing intelligence services activities when dealing with counterterrorism in relation to privacy and data protection. Article 8 and Article 17, respectively, of the European Convention and the Covenant. So once again, let me start with a question, because everything comes down to it. Why caring? Why should we care about privacy and data protection when dealing with counterterrorism? I mean, it's such a lesser sacrifice. So there's such an imbalance between the two that counterterrorism should always prevail. It's much more important as long as national security is clearly much more important than the right to privacy of a single individual, for example. After all, the secret services, intelligence services, and security services are not there to pack scandals or forge evidence against unwanted individuals. They are there to protect the democratic order. That's what they're meant to be. Now then, let me answer this question with the words of the European Court of Strasbourg. Now, the court held in Rotaro and in many other judgments, a system, quote, of secret surveillance designed to protect national security entails the risk of undermining or even destroying democracy on the ground of defeating it. Now, let me make an overview of the case so that we will then move forward to a technical analysis of it. I'll get to the slide right now. All right. Well, the applicant in this case was a lawyer in Romania, and he was convicted for an offense after in the year 1948 he tried to publish a pamphlet, and this publication was prohibited by the authorities. And as a reaction to this, he was complaining that there was no freedom of speech. So he was ultimately convicted for some kind of insult or offense of that kind whatsoever. When the communist regime went down later, many decades later, he filed a special proceeding that was allowed for those who had been persecuted by the previous regime. Within that context, he obtained entitlement to pensions in proportion to the conviction he suffered, because he was even jailed for that. So he won his case, but it's irrelevant to us. What's relevant instead is that in that file case, a letter was found that the ministry, as a counterparty, received from the intelligence service, the Romanian intelligence service, RIS, where a number of some information was set out about him. He was depicted as a member of a group called the Students' Legionnaire or something like that, and also this criminal conviction was reported in this letter. So there was a file that passed from the old secret services to the new one, and it was obviously unbeknownst to the applicant. So the applicant sued the RIS for damages and to have the file destroyed or at least amended. All he got was at first a rejection by the domestic courts. Then he filed an application before the court. By the time it was the commission, and meanwhile, a finding also was reached by domestic courts that the record about him being a member of the student group was false, in as much as it was not possibly true, because he would have be 16 by the time of his participation to the group, and at that age he could not possibly attend the university where the group was hosted. So basically, as I said, this is quite a complex case. It's quite a complex case. So after all he got was judgment in the end, setting out that all the records included in the letter and in the file held by the services were null and void, but he could not obtain any destruction of the file because there was a law providing for the secret services to hold those information even though they were passed from the old ones. And also no damages were awarded to him. So as a consequence, he moved ahead with the case in the European Court of Human Rights, who released a landmark judgment by the Grand Chamber, setting out all the severe shortfalls of the system, of the Romanian system, as to regulation of the intelligence activity and service by that time, and ultimately finding violation of Article 8, right to private and family life, Article 13, right to a remedy, and also Article 6, right to a fair trial. So it's important to note that in these cases, the court uses a scheme to assess the claims that are brought before it. So basically, the scheme is developed around an interference, and this is the first very important point, but that we have to address and to discuss very thoroughly. So what is an interference to Article 8? Is data protection, first of all, is data protection a fundamental right that can fall within Article 8 scope? The answer obviously is yes. Yes, data protection can be regarded as a fundamental right, not only for the profile of establishing relationship, but to the very profile of self-determination under an informative standpoint, which is something that has been set out in more recent judgments, but nevertheless had been recognized since the 90s at least by the court. So was there an interference or not? Now, it is very interesting to know that Romania tried to get away with this argument that not only was necessary that data was collected, stored, but also they had to be used, and they and that there had to be some kind of obstacle or outright prohibition to file any challenge, to refute the data, to hold that they are not correct, or simply to ask for cancellation. Now, the court provided a response which is in line with the with all European systems, if not all. I mean, the biggest part of European systems are consistent with this choice to consider that an interference with the right to privacy and data protection occurs anytime data is simply storage. There's no need to be used. Intelligence services are interfering with data protection regulations and privacy laws anytime they collect data. It is not, under this standpoint, it's relevant that they make use of that. As we might came to know, in the United States or in countries like UK, the case is for the opposite solution. So an interference is not envisaged when the mere collection, where the mere storage of the data takes place, but also used is required in order for the concept of interference to be reached by such activities. Well, let me specify that an interference is not in itself a violation of a right. As we all know, an interference may be lawful if it is justified. Okay, and we will see what the structure of Article 8 is in order to justify such an important activity. So, as I said, the court simply held that an interference was existing, even though it was not necessary to demonstrate to show that there had been a use of the data or any refusal to allow any change, which, by the way, ultimately, as a matter of fact, occurred, in my opinion. But as I said, it was enough to have storage of the data. Now, it is true that probably a high percentage of cases where violation of Article 8 is found might be related to the lack of necessity in a democratic society. As long as the European Court of Human Rights sets out a 3-point test, 3 main points test after, of course, an interference has been found. And this test is consisting mainly of the following points. First of all, there should be legal establishment of the measures that interfere with Article 8. So there must be a law. In principle, there must be a law. It is not possible that anything that limits a fundamental right can be carried out without a prior law existing and regulating such an activity. Then you have a legitimate aim, meaning something that functionalizes the activity, the investigation, the preventive measure in such a way that it is not deployed in an arbitrary manner. It is oriented, as I would say. And then the necessity in a democratic society, that is basically the red line. Even if there is a legitimate aim, it should always be tested against a necessity in a democratic society, not only for its mere existence, but also not only in principle, but also for the procedures, the way it is carried out. Some measures might be completely justified in principle, they might have a legitimate aim, but in the end they are carried out in such a manner as not to allow for any guarantee, any safeguard, which is not consistent to our democratic inspiration, our principles, as long as even the modalities could be triggering too high a constraint of fundamental rights. Now, in other judgments that have a similar structure to Rotaru, it's interesting to note Zakharov against Russia, where once again we have a big point on the profile of accordance to the law of the system of interception in a country. In these cases, as I said, we have a clear development around the principle of the rule of law, in as much as the court is not limiting itself to hold that that legal provisions are in place, but also it assesses whether those legal provisions satisfy a quality of law requirement. So a law, it's not enough to be existing. It must also be precise, detailed, set safeguards and procedures, and also allow for remedies to such an extent as to avoid arbitrariness and discretion and ultimately abuse. If this is not the case, Article 8 is violated under the limb of accordance with the law. And as I said, this is a common ground with the previous Valtonic case that I discussed, as long as the Special Rapporteur for Human Rights while countering terrorism has set out poor definitions in the law, undermine the rule of law, and open the doors to abuses that can, in that case, limit freedom of speech and undermine democracy itself. And once again, in this case, too broad, too lax legislation has been the prerequisite of a violation of Article 8 against the applicant. As long